Okay, I think we've got quite a few people on here, so we can go ahead and get started. Hopefully, I'm going to mute everybody. If you want to talk to me, you have to unmute yourself. All right.
What do we need for this meeting? What do we download?
Okay, they should have sent you all the new forms.
Yeah, but what are we doing today?
Today I am going to cover the financial addendums, the exclusive rights, and the sales contract change. And then Monday, we're going to come back again Monday, and I'm going to do the new home sales addendum and the lease changes. Okay?
Okay.
All right. So first thing I want to make sure everybody understands, these forms go into effect January 1, these changes. So if you write a contract between now and January 1, you'll be using the old forms. So all the interpretations with the old forms would, at that point, be interpreted under this old change. I mean, under the old forms. So when you have questions of me in the future, in at least the first 2 months, we need to make sure we know the bottom of the form. If you look at the bottom of the form, it has the form number and the date. Okay. So when we discuss in the future, I need to know, are we talking a case that was under the old forms or the new forms? It's not that these changes aren't as drastic as in the past, but you know, it could still be interpreted a little bit different depending on when it was. Everybody understand and okay with that? Okay, good. So the first form I want to start with is the exclusive right to sell listing agreement or exclusive agency agreement, whichever one you want to pull out. And the exclusive right to sell unimproved land. The change is the same to all of these forms, okay? But let's first talk about the difference between an exclusive agency and exclusive right. Does everyone know what the difference is? Okay. So here it is. An exclusive right listing agreement. No matter who sells the property, the owner, you, another agent, you get a commission. The exclusive agency, you use an exclusive agency agreement when you're reserving the right for the seller to still sell the property to another party, and there'll be no commission. You have to get it right. If you enter an exclusive right listing into the computer and you reserve the right for the seller to still sell the property without a commission, and some other agent brought a contract back with that protected buyer, you'd be paying the other side the commission, not the seller. So make sure you get those right. Okay. Now I'm just pulling out the exclusive agency agreement. And the first change is to paragraph 10. Paragraph 10. So if you will find that one or the exclusive right, it doesn't matter, it's still paragraph 10. I want to discuss paragraph 10 of this with you. This is marketing the property. So the change you will find in paragraph 10, D as in David. D as in David, and it's coming soon. So I want to make sure everybody also understands what coming soon regulations are as far as Bright MLS and NAR. And remember, this is only a member of a board of realtors. So since we all belong to NVAR or whatever board you belong to, you are bound by this. If a broker does not belong to a board, they don't have to follow these rules. Okay, so I get calls sometimes, well, you said we have to do it, but this party isn't. Well, that's because that party is not a realtor. Okay, so um, let's just look at paragraph D. Everyone find it, I hope. Seller authorizes or seller does not authorize broker to list property under coming soon status in MLS. If seller authorizes broker to list property under coming soon status in MLS, broker shall list the property under coming soon status within 3 business days of commencement of the listing period. Bright MLS has definitions. If you ever go to Bright MLS, decide where, when you log in, there's a box that you can check about the regulations. You can read this. But a business day in this sense, okay, is defined by Bright as Monday through Friday, unless it's a holiday. So if you list the property on Monday, you have Tuesday, Wednesday, Thursday, it has to be in the system. If you list it on Friday, Saturday and Sunday don't count, so you buy yourself some more time. So if you wanted to put a listing on the market on Friday, you list it and you don't want to enter it until the next week, you could basically hold open houses, do that type of thing, and you have not violated anything. Okay. Now, your problem here, if you list it as a coming soon, okay, any type of advertising, a sign in the yard, a flyer on your website, then it has to be in the system within 1 day. Okay, 1 day. That's the big difference. Now, if you were going to put it in coming soon status into the Bright MLS, okay, let's read the rest of the paragraph. Property may be listed in MLS under coming soon status for no more than 21 days from the date the listing is entered in MLS, except when a longer period is permitted by applicable MLS rules and regulations. That is what is added to this paragraph, okay, except when a longer period is permitted. So you have to have it in the system within 20, automatically after 21 days, it is going to then revert to active, okay? So if you have it in the system, then that is fine. It will automatically do that for you. Let me pull my MLS rules and regs here. I have them here somewhere to share with you. So this is actually from Bright. This is the status definitions, okay? Coming soon, all right? And this is what coming soon says. Subject to a listing contract and reported to Bright MLS, then you have that 21 days. The problem we run into is quite often we now see people put a coming soon sign up and they don't enter it into the system. If you're a realtor, you have to have it in that system and coming soon status within within 3 days, 3 business days, right? Now, it goes on to say, and this is why they made the change. This listing has not been yet on the market and will be on the market soon. A listing contract has been executed, but the property cannot be shown. So when you put it in coming soon status in Bright, no one can show it. Not the listing agent, not another agent in a firm, not a co-op agent, period. All right. Now, these listings are limited to 21 days in coming soon status, and this is why they made the change here, except for new construction, condo conversions, major renovations for which there is no occupancy, no active certificate of occupancy, and you cannot show it, okay? So under those circumstances, the coming soon sign could be out there. It could stay in the system for more than 21 days. Everyone okay with that? Now, here's a question that comes up quite often. If I can't show it, and if the listing agent cannot show it, how come we have ones in the system that says 0 days on the market? They got a contract and they, they wrote a contract themselves or whatever. And while it was in that coming soon status, this isn't fair. Well, here's the deal. Right MLS says during the specified period, the status of property is in coming soon if the participant, that's the broker, receives an agreement of sale, whether solicited or not, it must be presented to the seller in accordance with applicable laws and regulations. And our state law says all written contracts must be presented to the seller. So if someone sent an unsolicited contract over, it needs to be presented. If a buyer just said, look, I want to write a contract, I don't need to see the property, and that does happen, then that contract does have to be presented. So that's generally when that happens. Any questions about that? If you have any questions, unmute yourself and ask. All right. Okay. Then the next change to this exclusive agency or exclusive right, whichever one you have, comes in paragraph 19. So if you go to paragraph 19 of whichever one you pulled out, and remember, it's going to be the same whether it's form K1336, 1337, or 1355. These changes are the same. So paragraph 19 deals with property condition. Okay? So let's just go through this paragraph together. Seller acknowledges that broker has informed seller of seller's rights and obligations under the Virginia Residential Property Disclosure Act. It is or is not exempt from the act. And remember, there are properties that are exempt. But I would rather you just go ahead and get the form filled out and not worry about whether it's exempt or not. If not exempt, seller has completed and provided to the broker a residential property disclosure statement or any other applicable disclosure as may be required. So remember here, in our contract and under law, this property condition statement must be given to the buyer before they write the contract or before the seller ratifies the contract. If not, you still have a contingent contract where the buyer in the future could give notice after they receive that property condition form that says, I'm voiding the contract, and they have the right to do that without penalty. So this is one of those things you need to get filled out right up front if you're not doing it. Download it into Bright, have it there as a document. And you listing agents, when you get a contract in, have a checklist, develop a checklist and make sure you have every form that you need to be presented. Now, remember, NVAR came out with a new form in July that I absolutely love. And that's a property information input sheet that you fill out with the buyer, with the seller, to have all that important information to put a contract together, and you can download it into the system. It's not an addendum, but it's a form that completely helps the buyer agent with all the answers to questions like paragraph 6, where do we send everything to be delivered to the seller? Or paragraph 14, FERPTA, what's the answer, yes or no? What comes with the property so we don't have to guess? So if you're not using that form, I would suggest you use it when you list a property, download it, all the information that buyer agent needs to put a really professional contract together. And we all look better when we have professional contracts to be presented to the seller. Maybe I'll just add that form. If you're not familiar with it, maybe we'll add it to Monday's session when we cover the rest of the stuff I'm not going to get to today. Okay. Now, we're going to find this change to this paragraph in the second part here. Seller acknowledges broker may receive from seller or otherwise reports, surveys, plats, home inspection reports, appraisals, homeowner or
Không dám có
third-party
nhà hả?
warranty information,
Thì
or
sao?
other similar documents
Không,
concerning
tại cái này
property.
bạn nghe cái này là cái này.
Let me mute everybody again. Okay. Seller, and this is the change here, seller acknowledges broker is required to disclose to prospective buyers all material adverse facts pertaining to the physical condition of the property actually known by the broker, including any facts contained in property reports. So when we get these home inspection reports in, and it shows a known material adverse fact, you would have to disclose that, okay? You would have to disclose that. So I got somebody here in chat, what form the listing agent should use for property condition. That is the mandatory disclosure form, a property disclosure form, and it says there's no real disclosures on it. It says the buyer needs to go to this site to see all my disclosures, unless it's one of the 5 mandatory disclosures a seller must make in the state of Virginia. So that site that the form directs the buyer to not only has the 14 I'm not telling you I have, but it has the 5 affirmative disclosures that a seller must disclose. So I go over that with the seller and the buyer, needless to say, but go over the form with the seller. They have to fill it out, but make sure they understand the site does have their 5 affirmative disclosures. Okay. Now, here's another part added to paragraph 19, basically. Broker shall not, however, be obligated to discover latent defects in the property or to advise on property condition outside the scope of their real estate license. That's what our state law says, right? I don't have to look for problems. If I know problems, I have to disclose. Okay. Now, this is the part that was added that's really important to us. Seller may authorize broker to deliver any property reports to prospective buyers. Can we give that home inspection report that they received on the property to another buyer? I'm telling you, don't do it, okay? But what it's saying is, if the seller wants to take the responsibility for whatever's in that report, if it's wrong, and they'll relieve you of that duty, it's okay. The reason I say don't share a report with someone else that you received on one of your listings, that report wasn't done for any other party. That person had a contractual relationship with that home inspector, that first buyer, to do the report. And to rely on a party that wasn't working for someone for the information, and if they were wrong and they want to go back and try to sue the party that delivered it, guess what? You're the party, okay? Because how can they sue a home inspector that they did not hire? So do not share those. And beside that, have you ever had something come in where a home inspector showed it as a problem and it wasn't a problem, that they were outside of their scope of expertise? Like they're saying that that's not a settlement crack, that it's a structural crack. You need a structural engineer because they don't know the difference themselves. So don't share those reports. But if it is a known material adverse fact and your seller hasn't gone out and gotten an engineer or somebody to invalidate that claim of the home inspector, then you must disclose it. And our state law says in writing. Okay. Now, the seller, if the seller wants you to hand those reports out, seller shall indemnify, save, and hold broker harmless from all claims, complaints, disputes, litigation, judgments, and attorney fees arising from any misrepresentation by seller or authorized delivery of property reports. The problem is if the seller leaves the area, okay, good luck getting all that money back that you're going to spend in lawsuits because you gave something out that wasn't done for that client. So please, I'd be worried about that. If a material adverse condition were known or discovered prior to listing but was fixed prior to listing, is it still an obligation to disclose the condition is the question I have here. If it was done by a professional and the repair was done by a professional licensed party, then it's no longer a known material adverse fact. And so it would not have to be disclosed. Now, let's make sure you understand. It's a known material adverse fact, not a known material adverse defect. Most agents think it's a defect, okay? So a defect would be, so we have here, a defect would be, it's raining right now here in Mineral. We're expecting a bunch of snow, nothing. My granddaughter from California is so disappointed. She was up early to see snow. But if the roof leaked, okay, today, that's a defect, okay? If I got that defect corrected, then it's probably no longer a material adverse condition. But what if my roof had leaked 7 times this year? Okay, 7 times already this year. If that's the case, okay, if that's the case, and I've had it repaired 7 times, and now we just had an 8th leak. The defect was corrected, but if you were a buyer and you knew I had repaired my roof 8 times this year, would you want to buy that house the way it is? If you would answer yourself, no, I'd probably want an inspection of the roof if I knew, or a new roof, then you've answered your own question. That's a known, it's material, it's adverse, and it's a fact. My roof has leaked 8 times. Then that's something you might have to disclose. And most agents think it's not leaking right now. I don't have to disclose. That's not what our statute says. Our statute is known material adverse fact about the physical structure of the structure or the property inside the property line. Okay. So when we rely on these reports from a party that did not do the work for us, that we had no control over, and we don't even know what kind of report was ordered, I'm not giving it to a third party. The seller wants to give it to them, that's fine, but I'm not doing it. I'm not putting myself in the middle of that liability. So what they did with paragraph 19 is they put that hold harmless in for us. Seller, you want me to do this? Fine, you take the responsibility. But it says they'll reimburse us, but we're the ones that are going to be being sued, right? Any questions about that? So that was the changes made to the exclusive right, exclusive agency, and the any one of those disclosure forms. Okay. Now, let's take a look at VA, FHA, USDA appraisal contingency addendums. And we're going to have to look at each one of these to see the difference, okay? Because somebody have a question?
I have a question
Okay.
about the property condition. So I'm a little confused about about the reports part. So if I had a listing and somebody made a contract offer and they did a home inspection and they found 5 things wrong and they backed out of the contract, then I relisted it. Do I have to say all those things they found?
Well, it depends on whether it was a known material adverse fact. What did they find? If they found a roof leaking, that's a known material adverse fact. If they wanted the bathtub caulked, that's not. So you would have to look and say to yourself, and here's the questions to ask. Look, I know this about the property, right? If I knew this about the property, would I buy it? If you say to yourself, no, that's adverse. And if you say unless, so you just told yourself, I am not buying this because I know this and I don't like it. And unless the seller will fix it, then I would probably disclose it. Okay.
So can the seller then say, okay, I don't want you as an agent because you know too much and get another agent and they don't know anything, or is it the seller?
They could, but you still have a listing agreement, so they can fire you from a personal services contract. I'm going through this with something in the company now. They have the right to fire you from a personal services contract. Okay, I don't want you to be my agent anymore. And if they say that, you need to take it out of the system. Okay, but that doesn't mean they don't still owe you money under the contractual agreement that you had. Okay, so unless the broker signs a complete release canceling the listing, they can use another agent, but they still owe money if you want to go after it. Okay, but you know, what are the 5 things that a seller has to disclose in Virginia? Okay, so the seller has to disclose if it was a meth lab, right? If it's a meth lab, there's a 1-page disclosure form. Another one is military aircraft, which we don't really have to use that form in Northern Virginia. What's another one? Let's see, we have septic system waiver. If they are living in that party under a septic system waiver, they have to disclose. If there's known material, not known material, if there's a fact that they know about their property that is in violation of statewide building code, okay, or zoning, and they have received an actual written notice, not that they know, but they actually have received a written notice, then the seller has to disclose, okay? And the new one is the retention pond for water. Remember, Chinese drywall is no longer one of these 5 they have to tell, okay? So those are the only 5 things that a seller actually has to tell about their property in the state of Virginia. Unfortunately for an agent, we have to disclose any known material adverse fact about the physical structure of the property once we know. If we don't know, we don't have to look for it, etc. Okay, so it puts us in a little different position. So I go over that with the seller up front. I want you to understand there's 5 things you have to disclose, you know, and then there, you know, 14 things in our law that you're not telling. You don't have to tell, but they need to find out on their own. However, if I know of any known material adverse fact about your property, I have to tell. If that shows up in a report, I have to tell. So sellers, anything you think I should know about your property right now to disclose to people. And if they said my property's in perfect condition in the state of Virginia, I have the right to believe what my client tells me unless there's evidence or reason for me not to. So if I tell you everything's fine, but it's raining and you see water dripping in through my ceiling, you can't ignore that. Okay, so we have a different duty than a seller does. And unfortunately for you as an agent, when you become a seller, you have to disclose everything. You can't hide behind the only 5 that have to be told. Okay. Now, a seller cannot intentionally hide a problem from a buyer, but they do not have to disclose it in Virginia. So our state law is a little different. If you're also licensed in Maryland, that's a consumer state, entirely different rules.
Okay, thanks so much.
Okay, now let's take a look at these addendum forms. For the first one, U.S. Department of Agriculture, USDA financing and appraisal contingency. Okay, now USDA is a good loan if you find a property that qualifies. You got to go out a little bit further to find it. But I want to deal with the appraisal contingency. on paragraph 5. So has everyone found the U.S. Department of Agricultural addendum form? So we need to look at the difference between each one of these loans. All right. So USDA amendatory clause. It is expressly agreed that notwithstanding any other provisions of this contract, buyer shall not be obligated to complete the purchase of the property described herein or incur any penalty by forfeiture of deposit or otherwise unless buyer has been given in accordance with HUD, a written statement by FHA, whatever, setting forth the appraised value of the property of not less than X number of dollars. What has to go in that blank, whether it's USDA, FHA, or VA, is the sales price, okay? The sales price. Now, the difference between USDA, FHA, VA, those three, and conventional, okay? The purchaser has the absolute right to void the contract if the appraisal comes in for less than the sales price. Absolute right. There's no, they don't have to negotiate or anything. Under conventional, there is a time for negotiating, and if we can't reach an agreement, it's out. Now they've added the same thing to here, but the confusion we had with the appraisal removal form that we will look at is that it did not state on that form that the purchaser had the absolute right under FHA, VA to void the contract without penalty. Even though the seller says, well, I'll take less money, the veteran or USDA or FHA can just say, nope, I don't want the house, okay? So they've had to put that in here. Now, here's the difference between FHA and VA and USDA. Buyer shall have the privilege and option for 5 days after receipt of the appraisal to proceed with the consummation of this contract and without regard to the appraised value by giving seller notice of the buyer's intention to do so. So VA and FHA do not have this 5 days written into it. Okay, so that's going to be your big difference. Okay, now if you the rest of this is the same as conventional, the negotiating periods, etc. We'll take a look at that in a few minutes. If you look at the VA financing contingency addendum, okay, the appraisal provisions. So VA is a little different than USDA. Right? It starts out with 5A. Now this is Form K1339, your VA appraisal, right? Notice of value. Expressly agreed, notwithstanding any other provisions of the contract, buyer shall not incur any penalty by forfeiture of earnest money or otherwise obligated to complete the purchase of the property. If the purchase price or cost exceeds the reasonable value of the property established by a Department of VA, the buyer shall have the privilege to proceed. Otherwise, all the way up until settlement, they have the right to stop unless we reach a written agreement to a different price. So VA doesn't have the 5 days built into it. Okay? That's the big difference between VA and USDA. Okay. And we will, paragraph 5B, upon receipt of the written statement setting forth the appraised value of the property, buyer shall deliver notice to seller. So all these now say we have to deliver the notice, okay? And you have a notice form, you know, for delivering, okay? That reflects and basically says the same thing as our contingencies here, but you have to send a notice form over whether you're going to void the contract or not. And the conditions under the appraisal form and the appraisal notice match up with 1 through 5 of these, okay? Also with the VA addendum, pay attention to paragraph 6, wood destroying insect inspection. This is not included in conventional or the other ones. Fences and outbuildings shall be included in the inspection and certification, and seller shall pay any wood destroying insect inspection. So under VA, the purchaser cannot pay for the termite inspection. It's against the law. Okay, so they've added that in here. I'm going to cover the negotiating periods and all when we, after we look at this conventional financing contingency form. Well, actually, let's save the conventional one till after. I want to take a look at the FHA, and then we'll look at the conventional and the form for removing. Okay, so with FHA, one of the differences with their contingency addendum for financing is that paragraph number 3. Remember, you need to have the HUD form 92564 for your protection, get a home inspection addendum, and I mean the form and the pamphlet. So don't forget to make sure they have those. Okay. Now we have appraisal provisions here. Paragraph 6, page 2 of 4. Basically the same language as the USDA, right? Except for there's no 5-day time frame. So the language is you know, the same until you get to the last sentence. The appraised value is arrived at to determine the maximum mortgage the Department of Housing and Urban will insure. HUD does not warrant the value or the condition of the property. Buyer should satisfy himself, herself, that the price and condition of the property are acceptable. Okay, so HUD's giving them that disclaimer. This is just to determine how much we were willing to put out for the property for you to buy it, but not warranting the condition. Okay. Now they also have a notice here at the bottom of this page 2 of 4. The dollar amount to be inserted in the amendatory clause is the purchase price as stated in this contract. You can't put a different price under how much it has to appraise for. We had a case like that where it came back less, and it was a FHA, and they were saying we're waiving the financing contingency. You cannot waive the appraisal contingency. You cannot waive the appraisal contingency in FHA and VA. The purchaser has the absolute right under statute to walk if it does not appraise. Okay. Now, if buyer and seller agree to adjust the price in response to an appraised value that is less than the purchase price, a new amendatory clause is not required. You don't have to redo this. Whatever the new price is what they will have to go forward. If they're going to go ahead and take a property that did not appraise and they want to go forward, then they're going to have the cash difference out of pocket, and they're going to have to prove that they can do it. Any questions about that? Now, I want to take a look at conventional financing appraisal contingency. All right. Now, it matches up with our appraisal contingency notice form K1349 that we'll look at in conjunction with this. So conventional contract is or is not contingent upon appraisal pursuant to this paragraph. Buyer shall have until 9 p.m. X number of days following the date of ratification to obtain an appraisal. Okay. They're saying a minimum of 21. With COVID, it might take a little bit longer. If neither box is checked, this contract is contingent upon an appraisal pursuant to this paragraph, and the appraisal deadline is the financing deadline set forth above. Now, buyer shall deliver notice to seller by the appraisal deadline as follows, okay? So appraisal contingency notice. This is a form that a lot of agents still aren't familiar with. So that is form K1349, okay? So if you pull out your appraisal contingency notice, these paragraphs in the appraisal contingency notice, they match up with your conventional VA and FHA financing choices. But on this appraisal contingency notice, you will see at the bottom now, for FHA, VA, USDA appraisal contingency only, the appraisal is less than the sales price and buyer elects not to proceed with consummation of this contract. So they added this because people were coming back and saying, no, you had to negotiate and do whatever, because they weren't reading the paragraph 5 where it said they have the absolute right to walk if they don't like the appraisal. So they wanted to make sure everybody understood this is only FHA, VA, or USDA. Under conventional, you send the addendum form over. Basically, if the seller will lower the price to the appraised value, the buyer has the option of going forward, not the automatic option to get out, or they can say something less. So let's take a look here at appraisal contingency notice. This notice is given on in accordance with the sales contract, etc. And it deals with VA, FHA, etc. Buyer hereby provides notice to seller as follows. And every one of these financing addendums call for this notice to be sent over, choosing one option. If you choose more than one option on this form, it's not valid. Okay, the notice is void. You only choose one. So the appraisal is equal to or greater than the sales price. The appraisal contingency is satisfied and removed. We're going to settlement. Everybody's happy. Now, what happens if the form isn't sent over? Okay. Then if it's never sent over, the purchaser under VA FHA has the right to just void the contract. Okay. If this is not sent over, the appraisal contingency. So if you don't send this notice over to the listing agent and the 21 days went past, what happens with conventional? Well, the appraisal contingency, okay, will continue up to and including settlement date, okay? However, upon expiration of appraisal deadline, the seller can deliver the notice to the buyer and the buyer has 3 days to void their contract. So why would you not send the appraisal contingency over? Saying that it appraised. Well, let me play devil's advocate. The buyer is kind of shaky on their financing, but you've already gone past all your days to remove stuff. You might not send the appraisal contingency over just to see if the seller would deliver a notice that your buyer either has to void the contract or send that appraisal over. You might be saving it. It's unlikely, but you might be saving it as a way to avoid a contract and get out without penalty. Because if the seller sends that notice and your buyer voids within that 3-day period, there's no penalty. Okay. Same way with the financing. It might be a ploy to, try to save your buyer some money when you know they've already passed their deadlines. Okay. Now, the next choice, the buyer elects to proceed with consummation of this contract without regard to the appraisal. Okay. The appraisal contingency is removed and they will go to settlement. So, no matter what happened with the appraised value, I will bring the difference to the table. Okay. The third one, and this matches up with your conventional and your FHA and VA contingencies now. The appraisal is equal to or greater than the sales price, but the buyer is not going to go to settlement. because the property does not satisfy the lender's requirements or the appraisal does not allow for specified financing or property is inadequate collateral. And who determines that? The lender, okay? You have to understand, even if the appraised value came in, the appraised value came into them, okay? And it showed the property appraised fine. There's still an appraiser reviewer at the lender that has to accept it. So the person that reviews these appraisals is the person that really sets the value. It's not the appraiser, okay? So you could have one that comes in at the price, but the lender doesn't want to make the loan. It's not going to be adequate collateral, etc. Or this is the one that really used with conventional. The appraisal is less than the sales price and buyer elects to negotiate a mutually acceptable new sales price. Buyer's proposed sales price is, please see attached written statement setting forth the appraised value, and that cannot be less than the actual appraised value in that box, okay? Now, FHA or VA can use this, okay? They can use this also to go back and see if they can negotiate. So we send this addendum over, okay? Or under FHA, VA, they can just void the contract right then, not conventional. Conventional, you have to use this appraisal is less box. All right, so if you go to the appraisal contingency form for conventional, page 3 of 4, this notice has been sent over. They have said, we want you to lower the price down seller to X amount to the appraised value. The seller can agree or not agree, okay? But if D is being used in this notice, that starts a negotiating period for conventional. In the event of this subparagraph 5D, the party shall have until 9 p.m., whatever number of days you want to put in there, 3, 5, 1, I don't care, after buyer's delivery of the appraisal contingency notice to negotiate a mutually acceptable new sales price. So with conventional, you use this, okay? The buyer could say, I will only take it at the appraised value, okay? FHA, VA, USDA can say, no, I don't want it no matter what. Conventional, we start the negotiating period, okay? And at any time during that negotiating period, buyer or seller may make, modify, rescind, or alter as many offers and counter offers as desired to reach mutually acceptable terms. We can negotiate this back and forth orally, okay? But by the end of the negotiating period, if it's 3 days, by 9 p.m. on that day, there has to be a signed written addendum describing the agreed upon new sales price. Otherwise, everything we've been discussing and negotiating to that point terminates. So it says, otherwise, all offers and counter offers terminate. Now, you buyer agents, this is imperative. Buyer's election period. If you do not have a written addendum, you do not have a written addendum by the end of that negotiating period at 9 p.m., the election period begins. If at the end of the negotiating period, the parties are unable to reach an agreement, buyer shall have the option to void this contract by delivering notice to seller by 9 p.m., 2 days, whatever, following the end of the negotiating period. Otherwise, this appraisal contingency shall be removed and this contract remain in full force and effect at the original sales price. That means your buyer has to bring the cash difference to the table. If they don't, because you did not void in that election period, they're going to be in default. Okay, You can't mess that up. You okay with that? If they are going to send a notice to void their contract, make sure you use the form called notice to void, not the release of the contract. You would also send the release, but you would have to also send the notice to void. Now, if you go back to, for
Larry, what's the
instance,
number of this form?
of the notice to void, or
Notice to void.
I don't have it in front of me, but if you, it's in the forms library. It's called notice to void. If you have to void a contract for home inspection, you have to void it for homeowner docs, whatever, you have to use a notice to void. The best way to do it is use the notice to void form. I don't have it in front of me, but it's in the forms library.
Okay, it means we have to send notice to void and then to release the contract.
You can send both forms at the same time. They're two
Okay.
different forms.
Okay.
But if the contract calls for a notice to void, if that's a unilateral communication, this contract is over, right? If you only send the release of the contract and the deposit, that's an addendum. That's a bilateral agreement. If the seller doesn't agree to that, then you haven't voided your contract. You're going forward with the problem still intact. Okay. So that's, so make sure you get them right. Now, under FHA, under the FHA addendum, page 3 of 4, okay, you can go ahead and now they can go into this appraisal is less than the sales price. They can elect to accept the new sales price. They can do the same negotiating, but if they don't void their contract under the right to void on the appraisal and you're going back to do this negotiating, you're back to the election period and you're going to have to kill the contract when you get to that buyer's election period if you don't have that written agreement. So if you have a buyer that says, FHA, I don't want to void the contract. Let's see if they'll lower the price down. Well, you can go and you can do that negotiation, okay? But then since you entered that negotiating period, if you can't get that new price or they don't have the, if they come to something in between and they don't have the cash difference to come to the table, they're going to be in default if they can't settle. And now you would have to go back to voiding the contract by the election period. I mean, after the election period. So be careful. I would be interested to see how a court would rule if you didn't void it in that election period because they have the absolute right to void. I think it would probably work out in court, but I wouldn't want to be the test case. Okay, so everyone okay with these changes to these forms? And look, we're gonna do more of this on Monday at 11 a.m. If after you read through these, if you have questions, please ask. I'd rather you ask the questions, ask the questions before a problem arises. Because generally by the time it gets to me from one of the managers or whatever, we have people yelling at each other and threatening to sue each other and all that other kind of stuff. So, hopefully we will know more, and, the more we know in advance, the better off we all are.
Is the session will be on YouTube?
Do what?
Is this session,
Yeah, all the sessions once Nestor gets a chance to get it up there, all these sessions are on YouTube. So everything I've done prior today and this one is on the YouTube channel for Fairfax.
Yeah, because I missed part of the session. I would like to see it again.
Okay, yeah, so it is, Nestor does record all these and put them up on the YouTube for us. Okay. And
Oh my gosh.
I'll be glad to go over this stuff again. Monday, I do want to cover the new home sales addendum form. One of the things that's happening right now, if you had a purchaser that wanted to buy a home from a new builder, a small builder, because if it's you know, big builder, they got their own contract. You would use the new home sales contract form. But come January 1, that new home sales contract is going away. You would actually use your regular sales contract with this addendum, which pulls out some paragraphs of the standard contract. So that form will go away. Now, the only change to the actual sales contract is in the form, the addendums form paragraph, because they put these new home inspection, new home construction addendum and all listed there, but nothing in the basic contract itself has changed.
Larry,
For outside of the big builders, because they have their stuff, their
Yeah,
form,
the big
right?
builders have their own forms.
Right.
So if this is a builder that just builds 1 or 2, 5 homes a year, they may not have their own contract, okay? And this would be one you could use.
Larry, what is the difference between avoiding the contract or releasing the contract? Because I see the notice here, they are just releasing the contract. I didn't see any voiding for the contract. What is the difference
Difference between voiding,
and releasing it?
okay? So if, say, for the home inspection purposes, let's keep it simple. Your buyer got this long list of stuff and they don't want the house now. They can send a notice to void. So there's an actual form called notice to void, okay, in the NVAR library. We'll bring it up Monday so you can see it, or have it as a form for you. So this form actually says the buyer is voiding the contract in accordance with this paragraph of the contract or this addendum, and it lists on there, this is not a release of the contract, et cetera, because that's 2 different actions. So when it says you have to void, you use that notice to void. Do not send a release of the contract and ask for the deposit back form thinking you're voiding. They're 2 different acts, okay? So you would actually need both forms, okay? Just like homeowners docs or condo docs. Our statute says that the purchaser literally has to kill the contract, kill it, okay? Not beg for release, kill it. So how do you kill it? You void your contract, okay? Then you ask for the deposit and back, and you can do them both at the same time, okay? So I'll try to remember to have them add those 2 forms, and we'll discuss it again on Monday, voiding and release. Okay. Any other questions today? I know that's a lot to throw at you in one session. That's why I want you to take the time to read through the forms, and we'll rediscuss anything that we need to discuss on Monday, plus go over this new home sales addendum form.
Can I ask you a question about
Sure.
the 1031?
Sure.
Okay, the 1031, when we put it in the contingency clause, that we check that one. Then when we give it to the title company, what they have to do that? Do we,
You don't
the
give it to a
agent do
title company.
anything?
You need, if there's going to be a 1031, you need to get an intermediary, not a title company, unless they're going to be the intermediary. So, and it has to be a rental property. It can't be a personal property. And as soon as they decide they want to do a 1031, get in touch with a qualified, what they call a qualified intermediary.
Where can I find them? Do we have anything in the office?
Well, I've got Haran, I think it's Bob or Bill Haran, one of them is the person that their family's been attorneys and doing that forever. There's some information in my office about him, but you can Google qualified intermediary and put Haran, and that's who I've always had in my cases, but technically the seller would never have access to the money. They can't. Okay. So that would be.
Is it okay? Is it okay when you work with a title company, they do it?
The title company would do the settlement, but it would be the intermediary that's handling everything.
Is it any charge for it?
Oh yeah, they charge. It's not free. Okay. Because the money would never be in the possession of the of the seller. This intermediary would have it and they coordinate the two settlements, the one for the property they're buying and this. So the seller would be out of the middle of it completely.
Thank you so much.
Actually, I could probably have Mr. Haran do a 1031 class. He has a 1 hour 1031 class. I'm sure he'd be glad to do it for us if that's something you guys would like.
I appreciate it. Thank you so much.
So I'll contact him and see when he's available to do a class for us.
Thank
Okay.
you.
Now I've got a couple things here in the chat. If the buyer failed to send the appraisal contingency and unable to bring the cash difference, he won't be able to get the loan. Will he be protected? Well, if the seller doesn't send notice, they don't have the right to void. And if they don't get, and if they don't settle, and our contract says, if they don't settle for any reason, they are in default. So they have a problem. They're not protected by the financial contingency. If they don't remove it, because it sunsets, that contingency sunsets at settlement. Okay. Any others there?
Larry, if it's for appraisal contingency, it's past 21 days. You said you still have time to void the contract or negotiate?
Well, if you go past the 21 days for conventional financing, for instance, for the conventional appraisal, it continues on, just like the financing contingency.
Okay.
It continues on until settlement. It sunsets at settlement. So until the seller sends a notice, that contingency continues on. Okay. It continues on. But it all sunsets at settlement. So if they don't have their appraisal by then and they can't settle, they're going to be in default unless they get turned down for their loan. Okay.
You were talking about the 5 days for VHDA. I didn't get that part.
It's 5 days for USDA.
Yes.
Okay.
What was that
So
5 days?
once they get their appraisal back, they have, and it's less, they have 5 days to either void their contract or negotiate. Okay.
Okay.